All right, so today here's our agenda. We're going to be talking about how guarantees impact your personal assets as a business owner. And we'll go through some examples of personal guarantees in business financing. That's typically where you're going to be finding them. We'll talk about the parameters of personal guarantees so that whenever you're looking at one, you can be thinking about or identify the things that you really should be thinking about before you sign on the dotted line. Next, we'll talk about types of personal guarantees that are out there because there are all different kinds. And I'll definitely be talking about tips for limiting your risk from personal guarantees. So, along the way, I invite you to drop questions or comments in the chat, and I will definitely be going through your questions towards the end of the session today. So I'd greatly appreciate it and would be very happy to answer any questions that you have that are within my ability to do so. So let's kick it off. And I think the first thing that we have to talk about is what is a personal guarantee, right? Very basically, a personal guarantee is a contract where that you sign as an individual pledging to fulfill the debt of somebody else, and in this particular situation, a business, if that other person or the business fails to fulfill its own contractual liability. So you're basically a backup, right? You're the backup plan, plan B. Although in reality, sometimes you can be plan A, and we'll talk a little bit about that. So, in reality, the guarantee extends, the implications extend beyond the business entity, right? They go beyond the assets that are owned by the business, and they encompass or can impact the assets that the guarantor owns, your individual assets. They become liable, they become exposed to the claims of whatever the creditor is who has not been paid by the original obligor. And a guarantee, why are they out there? Well, I think it's pretty easy to understand that. They mitigate risk that a lender is taking on, and really they make it more likely that you're going to be able to borrow money or buy things on credit or whatever the underlying transaction is, and it just gets the money flowing for businesses. And access to capital is a big part of the success or failure of small businesses. And so personal guarantees are very common whenever you are owning a business. So here are some examples of places where you're going to see personal guarantees. Any type of a bank loan to your business. And one example is an SBA loan, right? We see those whenever folks are buying or selling businesses or getting access to capital. There's going to be a personal guarantee associated with that. A manufacturer loan, if you're buying something from a manufacturer and financing it, right, there's going to be a personal guarantee associated with that. If you're signing a commercial lease for your business, you're going to have to sign a personal guarantee in all likelihood. Maybe you're renting equipment. There are going to be guarantees in there. Supplier contracts. I've got an example of one for you later, like ordering on credit. So if you sign up and you're buying materials from a supplier, maybe you're a contractor and you buy materials from a roofing supply or building supply entity or business on credit, you're going to have to sign some type of a guarantee on that. Business credit cards, factoring arrangements where you are getting paid in advance on your accounts receivable, and those accounts receivable are being assigned to the factoring lender, right? You're going to sign a personal guarantee. So if they're unable to collect on your accounts receivable and they've lent you money on them, you're ultimately going to be responsible for that. Probably be a personal guarantee on that type of an arrangement. So whenever you are presented with a personal guarantee, and sometimes, that's the initial trick here, right? You've got to recognize when you're being asked to sign a personal guarantee. And sometimes it smacks you in the face because the top of the document says personal guarantee, but it's not always there, right? Sometimes it's part of an agreement that the business is signing, and there's some type of personal guarantee language within the context of that document. Or maybe they've buried it on page 52 and you've already signed your name 10 times in a business document and they just sneak another one in on you and you don't even look at it before you sign it. So you got to recognize when you're being asked to sign a personal guarantee. And in particular, you should understand what are the important aspects of a personal guarantee so that you know how to think about it, right? Before you decide to sign it, right? And let me just use an analogy of what I'm really talking about, right? So if your friend or your significant other says, would you like to go out to dinner? Um, you're going to ask some questions before you say yes, or then maybe you say yes because you never have anything else to do. But oftentimes you're going to ask questions like, well, when, right? Because you got to figure out, if you're available, where, if you're particular, like, where are we going to go to dinner? If you're kind of picky, what kind of food do we want to eat? Who's coming? Those are all examples of parameters to the request that you want to know better before you decide to say yes to that kind of a thing. And personal guarantees are basically the same thing. And so here is a chart that has some parameters that anybody who's being presented with a guarantee should really be thinking about, right? The liability aspect, what exactly am I agreeing to be liable for? How much, right? How much could I possibly be on the hook for? Sometimes that's easy to figure out. Like in the case of a loan, if you're borrowing $100,000, you're going to be on the hook for 100 grand at the very least, but it's not always easy, right? So if you're signing on a commercial lease, maybe the total amount that you have to pay on that commercial lease isn't exactly known, right? And there are personal guarantees that aren't exactly known out there. You have to understand that you could, in addition to the principal amount of the obligation, you may also be on the hook for interest, penalties, um, collection costs, attorney's fees. All of these things can increase the financial risk that you're taking on whenever you are signing on a personal guarantee. So you need to understand that. What's the duration? How long are you going to be on the hook for this thing, right? Does your personal guarantee go away after a year or two, or does it extend for the life of the lease until the loan is paid off? Whenever, that hard to tell, right? As long as the business has a relationship with that supplier, that could potentially be the duration. Or is there collateral? Are you pledging any kind of collateral in support of the guarantee? Sometimes you're asked to do that. It's not unusual at all for a small business owner who takes out an SBA loan that they are going to give the SBA a mortgage on their house, right? Or some other piece of real estate asset. So there may be some collateral pledged that is going to have an impact on you until that underlying business loan is paid off, because that mortgage is tying up the equity in your real estate, and you won't be able to use it for any other types of borrowing, or if you sell the house, it's going to have to be released. There are going to be other complications there. And then you really have to understand the legal provisions, the actual contract terms. We're going to talk a lot more about that. And it's really important. The devil's in the details in some of these agreements. They're not all exactly the same, and sometimes they're negotiable. And there are some that are worse than others. So it's really important to understand exactly what all of the terms mean, exactly for the extent, the duration, the triggering events for your liability, what happens in the event the underlying business doesn't pay. All of those things, super important for you to understand. So let's talk a little bit about types of personal guarantees. A full recourse guarantee means that you are on the hook for the entire obligation, whatever it is. Okay. Like we talked about, the principal amount of the loan, interest, penalties, collection costs, attorney's fees. You're in for a penny, in for a pound, so to speak, as they say. So you're gonna be responsible. Now there are also limited recourse guarantees, meaning you may be liable only for a certain portion of the debt, maybe up to a certain amount, or only under certain circumstances. Or maybe you've pledged only a certain types of your own assets that are at risk for the guarantee. There are lots of different ways that guarantees can be limited. So generally, that category of guarantee is called a limited recourse guarantee. Non-recourse guarantee means um, you might not be liable for it at all, or maybe under certain circumstances, or there are just certain assets that are off limits. So there are non-recourse guarantees as well. And then there are guarantees of collection, right? And what's important for folks to understand, and I think that they don't realize this, is whenever you sign most types of guarantees, okay, you might be thinking that the lender or whoever is entitled to the guarantee has to first sue the business and try to collect from the business. And if they go through all of that and they don't get all of their money, then and only then can they come after you on the guarantee. That's often not the case. They can sue you without ever suing the business. They can try to collect against you without ever collecting on the business. Oftentimes they sue the business and they sue you at the exact same time. So that's often the way it is. But a guarantee of collection is what a lot of business people, I think, conceptualize what a guarantee is all about, which is if you try to collect against the business and you're unsuccessful at collecting at the business, then you can come after me to collect on whatever the debt is. So that might be, if there's a good type of a guarantee, that might be the best type of a guarantee because you're going to have a lot of lead time to figure out what to do while the creditor is trying to sue the underlying obligor, the business. So let's move into some tips for limiting your risk, your personal assets from personal guarantees. And the first suggestion that I have for you in general is to eliminate ambiguous contract terms. This means you have to read the guarantee, or you have an attorney read the guarantee, right? And these are the types of things that when I'm looking at them for clients, these are the types of things that I'm looking for, right? So the scope of the guarantee, right? Exactly what is it that you're signing on for? What are you responsible for? Who are you responsible for? So there, you don't want to have a disagreement over coverage because ambiguous terms mean that you might think that you're responsible for one thing and the creditor thinks that you're responsible for something else, and you end up litigating over that kind of a thing. So you want to try to make it crystal clear in your contract documents what exactly it is that you're going to guarantee and what you are not going to guarantee. And believe me, when the lender or the obligee, right, sends you the guarantee, they're going to write it as broadly as they possibly can. Now, the duration of the guarantee, you're going to want to know a little bit about as well. And many of them, it's an indefinite period of time, or it's until the whole thing is paid off, if it's on a loan. So you want to definitely be looking at the duration of guarantee. And as we talk a little bit further about limitations, that might be an area where you can limit your exposure. What are the conditions of your liability? When does your obligation as a guarantor, when is it triggered? What triggers it? And that when a triggering your event might be in a loan agreement that the loan there's one payment missed and it's late. That could technically be a triggering event for your personal guarantee. But maybe if these documents are negotiated, there have to be more of a default or other things that have to happen before your obligation to guarantee a debt is triggered, right? There are lots of different ways to express triggering events, but you want to know when you need to start paying attention. What are the things that have to happen before you know that you're going to be on the front lines or be on the hook, kind of a thing. What are your payment obligations? Exactly, what is it? What are they going to be charging you for? How are they going to be accruing whatever the amounts are? You want to understand exactly how that's what's involved there, so that it's fairly clear, if that time comes, and I hope that it never does, that you have to guarantee something, that you have a pretty good idea, or you can figure out how they came up with the number that they're saying that you owe them. So getting down to the nitty gritty, maybe in the underlying loan documents, to say, this is how you're going to be charged. This is when interest uh, gets applied. These are the costs. These are the penalties, whatever it is, to make sure that you understand exactly how they're calculating all of that stuff, so that you can hopefully avoid disputes over amounts, because that happens very often. You get a nasty gram from a creditor that says the underlying entity is in default. This is the amount that they owed. You have no idea how they came up with that number, and there you go. There's a dispute over exactly what that is. It's expensive. It's time consuming and expensive to fight over those types of things. And oftentimes the money that you spend fighting over it is sometimes more than what the amount of the dispute is, or amount in controversy. So, just as a takeaway here, clear and unequivocal terms in a guarantee can reduce your risks, right? You really want to know exactly what it is that has to happen before you're going to be on the hook. So it is a worthwhile endeavor. It's worthwhile time spent to make sure that you have somebody go over with the fine tooth comb the details of these contracts. So here's an example of a sneaky personal guarantee. This is an actual guarantee that I'm fighting over right now, right? And this is on a form. It's a credit application with a materials supplier that a company had to sign in order to buy materials on credit. And this is at the bottom of the page, where whoever the representative of the company is, in this particular instance, the managing partner of the business, they had to sign. Okay. And it's a little sneaky, because if you look at this thing, there's a lot of stuff in here that pretty much just relate to the business. If granted credit, our company agrees to pay. It agrees that our account is COD. If we fail to pay, our company's financial condition is satisfactory. Oh, look at number 5. As an owner officer of the company applying for credit, I guarantee all payments due. Hey, that looks like a personal guarantee. Now, if you didn't read this document, if your assistant presented it to you, or if the account representative for the supplier presented this to you, you might totally overlook that. But I will tell you that this company considers that to be a personal guarantee, and that the owner of this business is personally liable for this debt. The company went belly up. This particular business owner is no longer affiliated with the business. They exited the business a number of years ago. And so they thought that this was in the rearview mirror, and probably never gave it a second thought. And in fact, didn't even think that they were signing a personal guarantee. But only years later, after the original company, the obligor, goes belly up, does this business owner get a nasty gram from the creditor's lawyer saying, hey, by the way, this company didn't pay, therefore you owe us $75,000 or whatever it is, to pay this account down. I think it's disputable whether that's even a personal guarantee, and that's the position that we have taken, and I've litigated over forms like this in the past. But I offer it to you as an example of how easy it is as a business owner to sign something that could potentially be construed as a personal guarantee, and there's basically nothing in there, right? There's no parameters, no details. It just doesn't really tell you a whole lot about exactly what it is that you're signing on, if you are in fact guaranteeing this thing. So just as a little real life example, and not uncommon, right? That's not unique. I've seen these types of forms many, many times. Okay, so next on our tips for limiting risk, if you're going to be involved in negotiating the terms of these personal guarantees, one approach or one tactic is to slow the process down, right? To give the business owner some time to figure out exactly what it is, what's going on, and what to do about it along the way. So you might require that the creditor give you, the guarantor, a notice that the underlying obligor is in default of whatever the underlying obligation is. Okay. If we go back to this little form here, there's nothing like that in here at all. Okay. Nothing like that in here at all. So got to get notice of default as as the business owner. Maybe I already know that it's in default. Maybe I'm the sole owner, but maybe I'm not the sole owner. Maybe I'm one of three and I have no idea that my partner isn't paying the bills, right? Maybe I'm one of five. I don't know what it is. But you might want to get notice of default. Um, and that notice often says you have to, if the account is in default for a certain period of time, maybe 30 days, 60 days, 90 days, then I have to get a notice of default so that I can figure out what's happening, what's going on, gives me a little bit of time maybe to have the company come up with some money to pay or work out some payment arrangements. I may also want to give myself the ability to cure the default. So instead of allowing the company to say you owe all of the money, right? The $100,000 loan, they missed one payment, so now the whole thing is in default. You owe us 100 grand. You might like to say, well, if there are only two payments that were missed, I'd like to just give you the two payments that were missed so that the default is gone and I'm not on the hook for the whole deal, right? So you may want to have the ability to cure the default. That's a lot less painful. It's not a happy thing that you might have to do, but it's a whole lot less expensive to cure the default than it is to um, pay the entire obligation. That's a pretty big limiting mechanism if you have the ability to do that, if they'll accept that type of a term. All right, next technique that we use to limit your risk is to cap your risk, right? So you might say, I'll agree to guarantee this loan, but I'm only going to be obligated up to a certain dollar amount, right? That's all I want to do. So, that's it. And you're asking either the lender to take on more risk if you're not going to be willing to guarantee the entire amount. And then the creditor will have to make a decision as to whether they're going to lend or what they're going to charge to lend. But you would set typically a maximum dollar amount. You may limit your obligation as a guarantor to a certain percentage of the loan or whatever the obligation is, or maybe even limit it to your percentage ownership interest. So if you're a 25% owner of the business, you say my max liability is 25% of whatever the amount, is owed. So you could try that type of a limiting technique. There are a lot of guarantees that are connected to revolving either line of credit, a revolving account. If you're ordering on credit from that supplier, this month the bill owed to the supplier is $70,000. You make a payment on it next month, and there's some additional orders. So the amount that you owe next month is $40,000. It goes up, it goes down, kind of a thing where you're taking draws on a line of credit or whatever. You may try to limit your exposure and say, we're going to take this line out. We're going to draw $50,000. I'm not responsible for any draws above that the company makes. So that's going to be it. Or if this loan ever gets modified or changed, my guarantee does not apply to any modifications or changes to that agreement. And there are lots of different ways of doing that, but that is another way to limit your risk, especially in a situation where you aren't the only owner. Now, if you are in a business with multiple owners and you're all asked to sign personal guarantees for a loan, you should really be thinking about getting some type of commitments amongst the business owners to share responsibility for the loan, because it isn't a given that if you and your three business partners each sign a guarantee to pay the entire obligation, right? That doesn't mean that you are only responsible for 1/4 of the debt. You could be responsible for the whole thing. We'll talk a little bit about that in a minute. And it is not a given that you get to go sue your business partners and collect from them their share of whatever it is that you paid. You should have some type of a sharing agreement of some kind, to have an agreement amongst yourselves as to how you're going to indemnify, meaning cover or make whole one another in the event one of you gets tagged for more than what you consider to be your share of the loan. Or maybe it's not your responsibility. Maybe somebody else screwed something up or stole the money or whatever it is. I don't know. But so having that type of a sharing agreement amongst co-owners is really, really important. Very, very, very often overlooked. Like you almost never see something like that signed, especially in the small business world, because people just aren't aware of how all of this stuff works. They sign it because, well, I got to sign it in order to get the loan, but they don't think about all of the things that they should think about to mitigate their own risk. But this is a good way to do it. And it's not part of the loan package that the bank gives you, because they don't care. They don't care what you're, as a minority owner of the business, they just want to get their money from whoever it is, and they don't care how you allocate it. That's up to you guys and gals. And so you figure it out. So the next technique would be to limit the guarantee. There are lots of different ways of doing that. One is to put a time component in it, to say, you know, my guarantee sunsets after 2 years, right? Or 3 years, or at some point in the lease. You sign a 5-year commercial lease. My guarantee is good for the first 3 years, but then after that, it goes away, kind of a thing. So I've seen that. You could also try to void your guarantee after meeting certain financial milestones that are relevant to whatever the underlying obligation is. So it could be a number of timely payments. That might be something that you'd build into the lease. Hey, if we've made payments for 18 months or 2 years on a 5-year lease, you're pretty well assured that this we're going to be able to pay, so it just goes away. But I've given you some comfort to know that we're going to be there to financially back whatever it is. It might be with a lender that your guarantee goes away when the company reaches a certain debt to equity ratio, which means that the company has more equity to cover the loan in the event it goes belly up. And there's enough money inside the business itself that the lender feels comfortable that they're going to be able to get paid by only having access to the company's assets, itself. So maybe, you know, you've bought one building and you've got a loan on that building. You might say, well, if we acquire another building, the amount of assets and equity that we have on the books goes way up in comparison to our debt. Maybe the debt was 1-to-1, but now with this other asset, it's the debt is 2-to-1. I mean, assets are 2 and the debt is 1, and the company, the lender feels more comfortable that they're going to get paid, and therefore they'd be more comfortable releasing your guarantee or having it go away. That's another way of thinking about it, that you might be able to convince them to let it go away. You might be able to negotiate it that says if you exit the business at some point in the future, that your guarantee goes away. And I think that is one thing that a lot of business owners don't think about, especially if there are multiple business owners. You forget about signing these personal guarantees, like that form that we looked at before, and you just don't give any thought to them. And sometimes year 2, 3, 5 down the road, that guarantee comes back to haunt you because you haven't closed that off so that you can move on with your financial life. If you're going to be exiting a business, it is very wise to be thinking about, all those potential liabilities that could come back to haunt you. You really want to make sure that you've done the things, you've signed the agreements, you've voided the guarantees, whatever it is, so that you aren't looking over your shoulder anymore. Frankly, a lot of business owners exit and they don't even think about those potential liabilities that are out there that could come back to haunt them. But the wise business owner really has that in mind as they're exiting to make sure that they don't have some time bomb waiting out there for them that comes as a surprise to them, oftentimes at the least opportune time, in their life. So, another way to protect yourself is sort of getting out of the guarantee in and of itself, right? Get out of the four corners of the document, get outside of the negotiating parameters of the document, and maybe you just retitle your assets. So, it's not unusual for me to suggest to certain businesses, hey, look, you've just borrowed on this business. You have a variety of lines of business that you're operating. Case in point, had a restaurant client who had a bricks and mortar restaurant location. They had a loan and there was a personal guarantee on all of that. I said, well, let's do this. They wanted to operate food trucks. Let's put your food trucks in a different business entity entirely that is not obligated on any of these debts of the bricks and mortar business, and there's no personal guarantee necessarily associated with them. It'd be difficult for them to sort of the creditor to get to those assets through your ownership interest in the business. They just want assets. That's kind of tough and difficult for them to figure out. But retitling assets or retitling new assets and other business entities is a one technique that we can use to kind of shelter some of your other assets and business interests from the potential risks associated with a personal guarantee. In some states, whenever you own assets jointly with your spouse, those assets cannot be divided and be exposed to creditor claims where there's just one of you is an obligor, like on a personal guarantee. They won't be able to, if they get a judgment against you, they won't be able to execute that judgment against assets that you own jointly with your spouse, like your home or your car, or maybe some investment accounts, things of that nature. That in some instances can protect those assets. And some creditors, if they're very savvy, they may ask your spouse to sign on just to make those assets available to them. But in many instances, the creditor isn't going to be asking if you're married. They don't understand what your assets are and how they're titled, and they're not really looking to get your spouse to sign. So it's just another way of potentially sheltering, assets out there. I've also seen it where folks will place a lien against their assets before they sign the personal guarantee so that their lien is ahead in line of the personal guarantee, along the way. It could be that you've lent money into your business and there's no loan agreement, there's no security agreement signed, and maybe you have all of that put in place so that the company has this secured obligation to pay this loan back to you or to an intercompany loan type of a thing, and that's there to block any guarantees on that type of a recourse guarantee to restrict those assets from their access. So the key takeaways from all of this today are as follows. Number one, personal guarantees are difficult to avoid completely. They are just part of doing business, especially for small businesses that don't have a lot of assets that they can pledge as collateral for loans. They're just a part of doing business. Almost every business owner is going to be asked to execute a personal guarantee at one time or another. Now, lenders may also not be willing to negotiate terms. Sometimes they are, sometimes they aren't. I personally think that it is a useful exercise to ask them to change terms in their agreements. You're going to find out what they're going to be like to deal with in the event of some type of a dispute or a problem that happens. If they're willing to negotiate, that's a good sign. If they're unwilling to negotiate, now on these loans before you sign them and they're willing to walk away, what that should tell you is you're probably not going to get a whole lot of grace in the event in the event that there's a default on the loans. You really should be expecting them to come after you with all the guns ablazing, so to speak. Ambiguous contract terms can create uncertainty about your obligation, and they really increase your risk from a personal standpoint on guarantees. So I really do suggest that you, number one, be on the lookout for anything that you're signing that could potentially be a personal guarantee. Like I said before, sometimes it's going to smack you in the face because it says right on the top, personal guarantee, but others are going to be a little bit more sneaky, like that form that I showed you and that you very, very easily could be overlooking, but be on the lookout for that. And you're going to want to have somebody take a look at those before you sign on to them, because it's a big risk. I mean, no business owner wants to have their business be put their personal assets at risk for things arising out of the business. Nobody wants to do that. So you want to spend some time taking a look at that to protect your personal assets. Unlimited liability clauses expose guarantors to significant financial burdens, right? And they are often beyond your initial expectations. What you think your liability is going to be is often different than it actually is, because you're not really thinking about the parameters that we talked about or the things that could be added on top of the loan amount that you think that you were signing on, or you really don't expect that the lender is going to come after you individually before they ever sue the business. You're not second in line. You're going to be first in line in many instances. So a lot of people don't expect that. That comes as a total surprise to them. And then finally, if you are a co-owner in a business, the guarantee probably says that you've got joint and several liability. That means that, again, if you're a 25% owner of the business, it means that the creditor can collect all the money from you, even though you are a minority shareholder. Just because you're a 25% owner doesn't mean automatically that your guarantee is only worth 25% of the debt. It doesn't work that way. They can collect all the money from you. Maybe you're the only business partner that has any personal assets. They're going to go after you and get it all from you. And if you don't have a sharing agreement with your co-business owners, you may not have very limited ability to collect anything from them to defray your costs. If the creditor came after you to collect all the money, the likelihood is that your business partners don't have any money anyway, and you're going to be SOL, as they say, up the creek without a paddle. So understand that whenever you sign on for joint and several liability, you're on the hook for everything, even though you've got co-business owners in the business. So that's what I have for you. Just a couple of short pocket notes. We've got some business health checks on my website, if you go to the business page, that help business owners assess their risk and conceptualize things that they might wanting to be thinking about a variety of topics. So you can sort of assess how healthy your business is overall with our introductory health check. We also have health checks about contracts, real estate matters, and HR related matters. So you may want to check those out. We provide a lot of content to small business owners. So if you're a small business owner or if you know them, by all means, invite them into our community. We send a weekly Legal Lowdown one topic email, always very timely. So you can subscribe to our weekly email with our little QR code there that you see. And we also have a YouTube channel where this session and other sessions that we've done will be recorded, and you can watch them offline. Or, if you know somebody that is in particular interested in personal guarantees, you can send them a link to watch this video later on down the road. We have some upcoming events, by the way. We'll have a Legal Lowdown in July, the ABCs of business contracts. Although it might not be the topic. I can't remember, Claire, exactly what our topic is. But we offer a variety of other ones. We do a lot of estate planning with my firm. So every Wednesday, my partner, Kevin, does a webinar at noon on wills and trusts. So if you're ever interested in that, noon Eastern Standard Time, you can dial in and attend that. Invite your friends. There's a lot of good information there. So, do we have any questions or comments that I can answer for anybody?